NASCAR is making headlines with its recent late-night disclosure concerning the potential sale of charters from 23XI Racing and Front Row Motorsports, FRM. This filing asserts NASCAR's position against granting a preliminary injunction to these teams, which could otherwise lead to the restoration of the charters they lost this summer. If the court denies this request, NASCAR will be free to sell off 6 charters that previously belonged to 23XI Racing and FRM. A pivotal court hearing is already on the schedule for August 28th, coinciding with the critical lead-up to the NASCAR playoffs. Excitingly, NASCAR claims there are many eager potential entrants ready to jump into the fray and purchase these charters. Although the organization has chosen to keep their identities confidential, the governing body contends that 23XI Racing and FRM have no entitlement to these charters, since they did not agree to the charter agreement for 2025. The anticipation surrounding the upcoming auction creates an air of suspense as fans and stakeholders wonder what might unfold. Bubba Wallace, a key driver for 23XI Racing, exemplifies the dynamic partnerships in this sport. Through this process, NASCAR argues that bringing in new teams could invigorate fan enthusiasm and inspire fresh innovation within the sport. They emphasize that these prospective buyers are not just names on a list. They possess a fervor for motorsports, alongside the necessary support infrastructure and proven track records in racing success. Such additions would potentially benefit everyone involved, from fans to competing teams, and even broadcasters, fostering a more vibrant Cup Series atmosphere. In their legal correspondence, NASCAR critically examines the significant arguments presented by 23XI and FRM in their antitrust lawsuit. One notable claim is that they do not operate as an unlawful monopoly, given that teams and drivers have the option to compete in alternative racing series like the Cars Tour. Furthermore, they assert that in modern history, they have not prohibited competitors from participating in other stock car racing events. Interestingly, the filing directly mentions none other than NBA icon Michael Jordan, who co-owns 23XI Racing. NASCAR alleges that he might exploit legal action to secure a permanent charter that would place him in a unique position. Initially, both teams were granted a preliminary injunction back in December 2024. But this decision was overturned by the Fourth Circuit Court of Appeals in June. As a result, 23XI Racing and FRM have continued competing as open teams, which has significantly impacted their finances and competitive edge. To mitigate this impact and ensure that they can continue participating in races, NASCAR has revised the rulebook to safeguard against the risk of either team missing races. This adjustment has made it possible for them to line up with a full field of 40 cars for the upcoming regular season finale at Daytona this weekend. Additionally, NASCAR points out that under the original 2016 charter agreement, it increased annual distributions to teams by a substantial 28% and further augmented that figure by another 62% under the current agreement. In fact, they draw a comparison with Formula One, stating that a higher percentage of revenue is allocated to chartered teams than what F1 teams receive. NASCAR argues that uncertainty over the fate of these 6 charters, should it extend past the trial, set to conclude in mid-December 2025, would hinder new teams from adequately preparing for the 2026 racing season. As they note, potential new owners would require ample time to get ready for one of the sport's most prestigious races, the Daytona 500, which is slated for February 15, 2026. Historically, NASCAR estimates that a new entrant must initiate preparation by no later than October 1st to ensure a strong competitive presence in the upcoming Cup Series.